Judicial philosophy is a concept that was invented for Supreme Court confirmation hearings. It is not something taught in law schools. There is no such thing as a judicial philosopher. That's not an occupation. If you had asked a judge about judicial philosophy prior to the era of contentious Supreme Court confirmations, the judge would not know what you are talking about and would give you an answer like this.
Over the course of my almost decade on the bench, I have developed a methodology that I use in order to ensure that I am ruling impartially and that I am adhering to the limits on my judicial authority.
Here's what the senior senator from Texas had to say about that.
I did ask her about her judicial philosophy. She says she doesn't have one and hasn't thought much about it. That's simply not a credible response, and I believe demonstrates a lack of candor.
30,573 is the number of times, according to Washington Post calculations, that Donald Trump publicly lied during his presidency. The number of times John Cornyn objected to those lies was 0. John Cornyn happily voted for a pathological liar for president twice. And then he came to the Judiciary Committee this morning to accuse Judge Ketanji Brown Jackson of lying under oath. And his accusation was about the intellectually vacuous concept of judicial philosophy. Senator Cornyn's comments were followed by Senator Sheldon Whitehouse.
Well, let's not pretend that a judicial philosophy is a neutral thing. It is a tool, and when a judge says he or she has one, it's worth looking into. But that doesn't mean you have to have one.
Leading off our discussion tonight is Democratic Senator Sheldon Whitehouse of Rhode Island. He is a member of the Senate Judiciary Committee. Senator Whitehouse, thank you very much for joining us tonight. I've been very eager to talk to you about so many things about this confirmation, including, of course, the most overused two words in any confirmation hearing, judicial philosophy. Let's begin there, because you alone during the hearings pointed out the absurdity of the very concept of judicial philosophy.
So let me just tee this up by pointing out that the last 3 Supreme Court judicial selections made by President Trump were picked by this dark money network. So when the Republicans are letting this dark money network pick their selections, then of course they're also letting them pick their objections. So where does it turn out that all this judicial philosophy talk, we heard the word 50 times in the hearings. It comes from a little group of groups that all share the same address, called Independent Women's Forum, Independent Women's Voice, Independent Women's Law Center. It's very attached to Leonard Leo, who's done all the judge picking, and his pair of front groups, 85 Fund and Concord Fund, which are funded by the Kochs and their foundations and the Bradley Foundation. And it was run by a Koch lobbyist for years, while she also ran Americans for Prosperity, the big Koch brothers political mothership. And surprise, surprise, in one of these organizations, you will find none other than Senator Hawley's spouse working. And they directed everyone, actually before Judge Jackson was even named, it is important that you focus not on the selection process or on the nominees' paper qualifications, but rather on the need to learn more about the nominees, and this is italics and bold, judicial philosophy. So that comes straight out of swamp, dark money talking points. And you see the same thing with the sexual predators angle on her child pornography sentencing. That came out of another front group with all sorts of creepy ties, including to the legendary Cleta Mitchell. And the guy who runs that one was Ted Cruz's Oppo guy in Cruz for President. So you've got Hawley and Cruz who are saying these things with like family members and staff feeding stuff to them from these dark money groups. If it weren't so sickening, it would be funny.
Let's go to that point about the possession of child pornography cases. This is a very simple objection to state, if you have it, as a member of the committee, to say there are 3, in some cases, some point to 4, child pornography cases where I wish the prison sentences you gave, because you did give prison sentences in all of them, I wish those prison sentences were longer. Now, that's how long it takes to state that. They spent hours doing it, and you showed very clearly at the committee that the reason this never came up a year ago at her last confirmation process for the Circuit Court of Appeals was because the dark money world had not put together this file for them to hand to them.
Yep. I mean, do you actually think Ted Cruz was running around in that elementary school library, pulling books off shelves, looking for something offensive? No, this stuff gets fed to them. And in this case, it was his old Oppo guy who was doing some of the research. And
this was enough to flip Lindsey Graham, who a year ago, when all of these issues were present, because all the issues they're talking about happened when she was at the trial court, and not, I didn't hear, correct me if I'm wrong, in all of the hours of hearings, I did not hear one mention of a single thing she has done as an appeals court judge that was raised by a Republican as an objection in this proceeding.
No, I mean, the focus was entirely on the child porn thing. They were obsessed with the child porn thing. And they really misled the public about what was going on in all of that, because their points were that she sentenced below the sentencing guidelines, where you can ask essentially any federal judge, the 2 worst sentencing guidelines are the crack versus powder cocaine disparity and this one. So it's absolutely common for judges to sentence below it because it hasn't been adapted for the internet age. And the second thing that they do is they pretend that the government is the only entity in the room. But at a sentencing, you've got the government and you've got the defense counsel, who a judge has an obligation to listen to and treat seriously. And you've got the probation department, an arm of the court, making its own sentencing recommendation. And they rather conveniently left out all of that and argued that she was sentencing below what the government recommended. Well, the government customarily makes the harshest recommendation, so that's no surprise either. So they set up a false frame into which to put her decisions in order to make them look like they were extraordinary when they're not.
The hearing that was held after Judge Jackson was finished, there was a separate hearing about qualifications. The American Bar Association group testified, had the unanimous, fully qualified endorsement from them. Yep. And then there was this golden moment actually provided in your questioning of one of the witnesses who the Republicans called in the hearing that was about the judge's qualifications. This witness did not say a single thing about her qualifications. They were just generalities against, I guess, his concept of liberal judges. And I just want to let the audience see this one more time. We ran it that night, but let's take a look at it now. What happened with this witness and this witness's credibility when Senator Whitehouse had his chance.
Is Joseph R. Biden of Delaware the duly elected and lawfully serving president of the United States of America?
He is the president of this country.
Is he the duly elected and lawfully serving president of the United States?
He is the president of our country.
Are you answering that omitting the language duly elected and lawfully serving purposefully?
I'm answering the question. He is the president of the United States.
And you have no view as to whether he was duly elected or is lawfully serving?
I'm telling you, he's the president of the United States.
No further questions.
Senator Whitehouse, a moment like we have never had in the history of Supreme Court confirmations.
They had some beauties out for that. Really astonishing, the people they dragged in for the witnesses. Usually it's a pretty distinguished panel.
And going forward, there's Judge Jackson's future in the Supreme Court is secured. There are now questions about Clarence Thomas's future on the Supreme Court and what cases he should be recusing himself from, given what we now know about his wife's communication with the White House involving January 6th. Should, at minimum, Judge Thomas recuse himself from all January 6th cases?
He should. And Chairman Hank Johnson of the House Judiciary Court Subcommittee, who's my colleague on the House side, and I together sent a letter to Justice Roberts asking him to apply his forces of persuasion to make sure that that happens. The problem here is you've got a judge who tried to interfere in the investigative capability of a commission that, with full investigative powers, would have discovered that his wife was communicating with people who were involved in the conspiracy to disrupt the election. So you really don't get to make a decision like that if you've got a family member involved, and particularly when the effect of your decision would be to inhibit the investigative reach of that commission.
Senator Sheldon Whitehouse, thank you very much for joining us tonight. We really appreciate it.
Quite a time.
Thank you, Senator.